Hello and welcome. You're watching NewsX. I'm Rishabh Gulati. They say morality is the root of ethics, ethics the root of law, and law the root of civilization. It seems rather simple, but in defining all of these is the complexity, the dynamic change that needs to be brought, because not every individual case can be transposed as a generic rule, and not every generic rule need apply to an individual case. Within this oftentimes modern day cacophony of a lot of noise, we have to distill wisdom, because this stellar growth that India is going through as it's re-emerging in the comity of nations is largely being stabilized by the continuity of its institutions. Think of the armed forces, think of the judiciary, the roles that are played and the roles that are not played, equally important. To shed some wisdom on this, we have with us Justice Sanjay Kishan Kaul, who's just retired from the Supreme Court. Justice Kaul, welcome to NewsX.
Thank you.
So let me begin with what has just recently happened since you were party to those proceedings. Article 370 and the judgment that has come from the Supreme Court. What is your satisfaction regarding the matters of sovereignty, autonomy, and the presidential orders?
So, we'll have to go back a little in history as to the assimilation of Kashmir into India. It followed a slightly different path, I would say, and that's the little distinction I've drawn in my judgment of whether some sovereignty survived or not and when it got extinguished. Now, looking to that background and the constitutional provisions, 370 was envisaged as a provision for a slower assimilation than an instant assimilation. You thus had the Constituent Assembly for the state, its recommendation, the Constitution for the state being enacted, Constituent Assembly ending in 1957. But thereafter, different orders were issued in a slow process of assimilation. And that's something which nobody has really challenged or which is not kind of not accepted till it came to a stage where the question was, is this permanent? Is 370 permanent? And whether it can be at all abolished at any stage of time. That's a political decision. The present dispensation of government felt that no, a time has come for complete assimilation and 370 should go. And that's what they did. Now, the issue before the court thus was whether 370 as a provision could be abolished or not was the first thing in a broad perspective. The second was the process correct or not? Now, the debate has been, of course, more on the second process than on the first. But there are people having different views on the first also that it should have been there. Well, we have seen almost 4 years in the absence of 370. There may be some aggrieved persons, but by and large the situation has been, as it developed, it's moving towards normality, I would say. Now, the 5 judges of this court found that it was a temporary provision, and if it was to remain permanent, there was nothing to indicate it was permanent, otherwise it would have been done away with then. These are questions of legal interpretations. But those legal interpretations ultimately culminated in the court coming to a conclusion that the government was entitled to abrogate 370. Coming to the second part of it, the manner of doing so, well, there was a peculiar situation which we faced, which was arising from the absence of any state assembly. So, there are views that no, it should have been by a particular method, government followed another path. On our analysis, this was, in the given scenario, a possible path which could have been followed, and that's what has happened. That leaves the issue of the state being reduced to a UT. Now, carving out a UT of states is not something new. It has happened before. So, really there's not much of a debate. Article 3 envisages it. The question which was sought to be raised was, can a state, can you carve out a UT and then the remaining state be also turned into a UT temporarily? Well, there could be one argument which was said that if a UT could be carved out, then more than one UT could be created. But we really did not have to go into it, or we did not go into it actually, because this question was posed to the government, to the Solicitor General, as to what is the government stand on this. And based on the statement made by the Home Minister in Parliament, it was said we will we will do that, we'll hold the election. So that's why the court stayed away. Now, from this, there are many situations where if the court does not feel the necessity to decide an issue in a particular matter, it leaves the question of law open. So that question of law has been left open in a sense.
Okay, let me just take you through the epilogue of your judgment, which of course is some very interesting things you mentioned there. You mentioned the need for a Truth and Reconciliation Commission on the South African model, specific to the state of Jammu and Kashmir, given the fact of what has happened there in the past 20, 25, 30 years. What is your thought process behind this? How are you envisaging this suggestion?
So, if you recollect, there was a hearing started a couple of years back on 370. And it was going ahead, and then suddenly it got a little diverted because the plea was sought to be raised that a 5-judges bench could not hear this matter. That, to some extent, inviting that opinion, which went against, diverted the hearing away, and then it took some time to again start the hearing with a different bench. Even at that stage, when the hearing began, my thought process was to firstly give a history to Kashmir. That's how I began my judgment. Because somebody has to understand the conspectus of that place, to how the history has flowed there, to understand the current scenario. The epilogue was something which I had in mind since then, because one has seen the troubled times over more than 30 years. Now, if we look at it, what India has faced in 1947, we had a huge displacement of people. Partition people went through problems. And it took almost a generation for people to reconcile or get back to it. The earlier generation would still, I recollect that, talking about Delhi, my grandmother would say, well, Lahore mein something, it would slip off whatever the tongue.
Yes.
Because my family came from Lahore and Bahawalpur and Kashmir, both. And that was a very common factor. But as time passed, generation passed, people adjusted to their new surroundings. Kashmir faced a similar problem because there had been loss of life, there were different discussions on what had happened. But the bottom line was that 4.5 lakh plus people had been displaced from the state almost overnight. Other than this acknowledgement, they have been displaced. Why have they been displaced? What they have suffered? There has been really no dialogue on it. And that's something which I think festers with the community. Apart from the fact that there should have been prosecution, an aspect on which I'm aware the community feels that, well, if in 1984 riots we can go ahead now, pin down the people, why should it not happen there? The other view was it's too far in the past, the evidence has disappeared, the two things can't be compared in terms of the diaspora which was there. So I felt that there must be a balm applied. The balm can only be applied when you first accept that something has gone wrong, something did go wrong. Then we had a scenario where a section of the people moved away and the army had to be brought in because you were fighting practically a war. Army and paramilitary forces fought a war. Any war creates its casualties. It creates its innocent casualties. So the people who stayed back had their own problems with the warlike situation which was there, which has bred to some extent distrust and a whole generation going not knowing how the earlier generation stayed together. It was one of the places where people really did not lock their houses. We could go out for walks. There was no problem. This was right till 1989 I've done it, where even if you're staying in a farm area, near a forest, you would go out for a walk with ladies. There was never a problem. So something had erupted. We must get to the bottom of it, acknowledge something wrong has happened, to apply balm to both sides in a way, so that people move forward. Because there's no point in looking back continuously. If you keep looking back, we will not move forward. So the objective was this: let's collectively move forward by applying balm to whoever needs that application of the balm.
Okay, so a Truth and Reconciliation Commission more as a dialogue process, a civil process, or a process which power and authority and structure to do investigation? How do you envisage it?
So the very concept of it is not to result in any prosecution. That's not the idea. But the idea is to get to the bottom of the truth.
Okay.
And so you get to it in how it has worked in Africa. People who did the wrongs came forth and said, we did that wrong. And the other side accepted that, and you accept an apology. So when things have gone wrong, it's not a clear, relevant example, but in a home also or in a society, sometimes you have to say, I'm
Yeah,
sorry
just
because you've done something wrong.
is the denial process at least, or the
Yeah.
ignoring of
Yeah.
something that's gone wrong.
Correct.
Okay, sir. Let's come back to now complex matters which pertain to the court. This entire episode of the NJAC. Now, after having had time to reflect upon it, sir, what are your considered thoughts now?
The constitutional scheme provided for particular methodology of appointment, which worked till 1990s. The judiciary, in its wisdom, thought there was a change necessary, brought about that change. And it is my view it worked well. But there was some amount of non-acceptance, I would say, by the political class as a whole, irrespective of which party they belonged to. They felt the judiciary itself could not take over the complete task, and it is they who should also play a role in it. Over that, debates were held, commissions were set up, and ultimately an act came into being, the NJAC, which was unanimously passed by the parliament. That came to be challenged because there were some issues in that NJAC which perturbed the courts. Amongst others was this aspect of a 6-member committee where I believe there could be a deadlock even if 3 judges was there, because it required a 4:2 majority to get something through. Now, I have spoken earlier on this issue. Should there have been a casting vote to the Chief Justice? Would some other method have been adopted to give credence? Ultimately, it was struck down. Now, all this happened in very quick sequence. So, it can be said that the method was not given a chance to see what was the problem. Could the matter have been kept pending and seen how it works? Or could the so-called tweaking have been done? But that's history. So the fact is that that chapter was over, and nothing prevents the government from getting another law into force, keeping in mind what has already transpired in that judgment, or what were the infirmities pointed out. Now, post the NJAC judgment, the political class has never been able to digest or accept that a law brought by the parliament unanimously has been struck down. That has brought a greater element, I would say, of tension in the working of it. So, you've had up and down processes. Now, what I have expressed is my belief: either operate this collegium system as the collegium system is supposed to operate. It provides for, it's not that only the judiciary decides it in a sense. Yes, the names emanate from the judiciary in the High Court, but there is a consultative process behind it. Maybe everybody does not know and may not know about how it works. So, it works in a manner where the Chief Justice sits with the two senior judges. But it's not only that. I've worked almost 4 years as Chief Justice of 2 courts. You take inputs from judges across the board. You take inputs from sometimes even retired judges whom you respect, from the bar, from otherwhere. You get an informal IB done. At least that's how I went about it. And then you have a pool of talent, you would say, to consider. Sometimes government also suggests names. And then you decide what names to recommend. The next process is the state government consultation. They give their opinion. The central government gives its opinion. The IB gives its opinion. Sometimes complaints are received, so they are also flagged. And all this material comes to the Supreme Court Collegium, where the consultee judges, who happen to be judges who have spent time in that court, give their own opinion. All this material is then placed before the first 3 judges of the Supreme Court to take a view to clear the name or not. Now, past number of years, if you see, the clearance rate is hardly 50%, sometimes even lower than 50%, which itself would show there is a check and balance. Now, after that, when the names are sent, government has a right to sometimes say, no, despite your clearing it, or maybe government initially had an objection and we have overruled that, to reconsider it. If they send it back, the court may reconsider it, but may reiterate it. Now, the two problems which are arising is, the lesser problem is the reiterated names. There are only 4 names pending of reiterated names. But the names which are recommended and not sent back has been, to my mind, a problem. So, we don't even know whether the government has objection, what is the nature of objection. Today, some 13 names are pending consideration for different periods of time. Now, if apart from that, even from that list, because when a person accepts judgeship and the collegium recommends it, it keeps in mind the seniority. So, when some people are appointed, some are not appointed, it disturbs that seniority also. That is another thing which has got flagged. And this is despite the fact that timelines have been laid down by a 3 judges bench of this court. So, some way that issue has to be resorted to, and I believe backroom dealing doesn't help. It's my view that NJAC would have provided the the platform for at least a dialogue between the government and the executive, not sitting out in the open and telecasting it, but to give their perspective. And that may have facilitated it. So we have today these names pending, we have 6 transfers pending, we had even 3 Chief Justices pending. Hopefully that should get through now, another 5 have been recommended. So these delays cause problem, and as it is, when we have so many vacancies, what happens is by the end of the year, if you see, broadly we fill in the vacancies which arise afresh. So the appointments are taken care of, the number of pending vacancies more or less remain the same, sometimes a little more, sometimes a little less.
Okay, so where have we moved on from the point of principle that became a difficult point, as you mentioned, that a political class, a legislative class, not being able to digest the fact, regardless perhaps of the subject matter, but the fact that a legislation could be struck down by the court. Have we moved on from, say, have we made progress, or is it still tense because of that?
No, I think it has made progress. Appointments have taken place. There's a little to and fro, but it's not as smooth as I think it should be.
Right.
So to work this system as it exists, and my concern is, if this is the law today, then it must be followed.
Fair enough.
If there is a law which government likes or doesn't like, is not material. You can have a different law, but it is the duty of a court to enforce the law.
Okay, fair enough. 52,000 record number of cases disposed of by the Supreme Court in 2023. Despite that, as you know, there's a large pendencies, 80,000 plus. So is this then the fundamental issue regarding pendency, or are there other matters that can be also brought to increase the number of cases being disposed of, reducing their time in court?
So Supreme Court, one of the developments has been to at least get the correct data. Sometimes the problem is that there was an issue of data, I would say, to get to it exactly what is the pendency, at what stage is the pendency. So at times these figures can be a little deceptive one way or the other, including whether it's disposal or whether it's pendency. The Supreme Court of India is not really a constitutional court alone. It's a court of appeal, practically speaking. Many and everything comes to this court as the final court. 2 out of 5 working days, which is Monday and Friday, we are sitting on miscellaneous matters. The number is large. There are miscellaneous matters either in the category of fresh matter or after notice matters, bail matters, transfer matters, petitions. So about 40% of the court's time is spent in deciding whether it's a case which needs to be finally heard or not. Now, that being the position, only 60% gets left for the admitted matters. Dismissal rates are quite high, I think, must be over 80%.
Right.
But judges have to read these files.
Yes.
They have to come to a conclusion. This is no weekend, unlike what people think. So you have to read it, get ready for a Monday, then starting from Wednesday, get ready for a Friday to see how to tackle that 50 cases plus which were listed before the court. So now we've not found an alternative method to it. There are different countries who do not give so many opportunities of hearing. US Supreme Court doesn't. It decides in chambers whether a court needs to be heard in open court or not. But this sanctity of hearing in our country is such that practically everybody is heard. Everybody gets that couple of minutes at least to work out what has to be done.
Okay. Let's talk about some of the judgments. We've discussed 370. So on right to privacy, sir, it's talked about as one of the landmark judgments. What has it fundamentally changed in the perception of people who is the citizenry of India and as information to government on what's okay and what's not okay?
So privacy as a constitutional right has been recognized. Even in that judgment, we recognize it has many ramifications. How will it work out? Time span will show. In fact, it was said that, is this a solution to everything? No. It's possibly the beginning. And litigation would be generated, I had observed, and litigation will work out in its own way. But to all our belief, and 9 judges felt that the individual's right to keep to himself information, especially when you are not let me say, a person in holding a public office, is certainly he is entitled to it. Also, I had mentioned about right to be forgotten. Something has happened at some phase of life. Now, unfortunately, the system is such that almost permanently information will remain there. It creates a problem. And some of these issues are now being agitated in courts as to what is the ramification of it. So, a law of privacy will evolve and the challenges are going to be more now. because technology, AI, other things coming in is going to raise the level of challenges and the possibility of intrusion into the homes.
Okay, since you mentioned it, what are your thoughts? Because the concept of AI and deep fakes and anybody can imitate you and me and make it almost real. And by the time we actually go through a process of countering that, it might be too late in serious situations. Are the solutions technological primarily? Is that where you see it? Technology has to answer technology?
Technology will have to answer technology, but it's a challenging issue. Often what is happening is that the development of the technology and its possible misuse keeps a little step ahead of
Yes.
how you keep checking it. But I believe, especially in our country, where there is so much of talent available in this field, we need to focus on it to see. And this intrusion can be a private intrusion, government intrusion, any kind of intrusion. I really feel that a person should be capable of being left to himself. Original society of the world worked like that.
Okay, now same-sex marriages. From what I've understood of the judgment, it is a matter that has been left to Parliament in a sense. But in your note, you mentioned the concept of civil union. So how do you understand the concept of a civil union, and what is the hope of people as the matter gets left to Parliament to legislate on?
Uh, this is a socially sensitive issue.
Yes.
So from where it began as a socially sensitive issue, even decriminalization. I was part of it because I just joined the High Court bench when we issued notice on this. And then the journey, I will not emphasize, it went through a dismissal, went through to Supreme Court, remitting judgments back and forth. So it took its own time to evolve in decriminalization. That raised hope of that community that the next step should be, because as people accept it, many countries in the world accept it, whether it can result in marriage. I think the issue was not only a label of marriage, the issues were what flows from marriage. So, adoption, inheritance, many other things arose. When the matters were taken up, there were some religious angles into it also. And those religious representatives had intervened. The court didn't want to get into the religious issue of it. So, what was thought about was, can we bring it within the ambit of the Special Marriage Act? The whole arguments proceeded broadly on that parameter alone. There were difficulties pointed out on the side of the government, and there were many other acts and enactments which would get affected. So, it found it difficult by everybody that we can't include it directly in a Special Marriage Act and leave the nitty-gritty to be worked out. So, one view, the majority view which has prevailed is that let the government do it. The marriage is not such a right, constitutional right, that it has to be taken care of in a judicial proceeding. We felt that something must be done, next step must be taken, the minority view. So, next step was, what do you call it? You don't call it marriage, can you call it something else? Because marriage has its own connotations under different religious laws. So, civil union was a phrase which was argued and was found to be, in the course of argument, an acceptable one by the minority, that it will give, it will not be called a marriage, but something else. I have at least said that it's the other side of the same coin. Not touching something which is sensitive from the religious point of view. And it would then work out how inheritance takes place, how does adoption take place. But it's a minority view. I believe sometimes these issues take time to emerge. I'm sure that community feels that there will be a time when the acceptability will be more. There's a difference between thinking of my generation and the younger generation, yes, which will come up. So it's a process of evolution slowly.
Okay, speaking of process of evolution, you've been involved in the hearings on pollution in North India. Now, it would seem that it is an obvious thing that we are all agreeing on it because we can all see it and we are all affected by it. So it should be a rather simple intervention. But again, it's a sensitive issue. It's a sensitive issue because it involves political considerations. It involves a community of farmers who are involved, who are both, who are also suffering from the pollution, of course. How have you understood how this is played out and how frustrating has it been?
So, this battle between development and environment is a larger plane always.
Yes.
And you'll see it play out in the country and world over in envy way. We've been trying to clean up Yamuna to what effect? Thousands of crores have been spent on it. We've not found a solution as such. Similarly, for pollution in the zone, it's not a single factor. So there may be farm fires. There are very number of vehicles here. Number of population, let us see. It's Delhi or North or this NCR region is bursting from more people than logically can be accommodated. Then use of in winters, use of fires. Sometimes there is a complaint about even issues of how the instruments and
Dust
others
and
are destroyed.
construction,
So
yes,
there are
yeah.
many ramifications of it. The government appointed a committee headed by the cabinet secretary with all stakeholders in it. Now, where I felt was that if the committee is there, see, the court is not technically equipped to go into it. You have to make sure that a technically equipped group looks into it. The practical view is taken looking to what the problem is and enforce it. So the court's job in these matters is to push ahead. It can't say, go take this suggestion and implement it, because that will be problematic in a sense, I think. And that's what the court has been doing. Now, there are suggestions made by that committee, there are technical people in it. What was happening earlier was invariably it would be taken up the matter at the time when the problem cropped up. And I felt that's not a solution. We took it up a couple of times, but I've left it to the next bench to do it so that it is regularly monitored. That's what I've said. The hope is that by the next year, at least there should be some improvement. There can't be a magic wand, but there should be some improvement in it.
Yes. Okay. Yeah, exactly. Some improvement. Okay. We got a few minutes left, sir. So let me ask you a larger question, because for people who are watching to understand, uh, judges of Supreme Courts are also human beings. They have an opinion, a viewpoint, a history, a life story. But do judges have an ideology? Because this is a raging global conversation. That is this a liberal judge or is this a conservative person? How do you understand it, or is it dynamic? It can't be put into brackets rather easily.
It is dynamic in the sense that human beings will have their own views. Is it said that the judge has no political belief? Can't be possible. Uh, you've had political people like Justice Krishna Iyer, a celebrated judge, come in and do a fantastic job in the judiciary. The question is the ability to segregate your personal beliefs and go by what is broadly called the Constitution. So you develop and evolve a personality whereby you can keep your personal beliefs aside. But yet it's not in absolute terms. So there will be judges who are perceived to be a little more liberal on, say, the bail matter, a little more conservative, a little more liberal on tenancy matters. So your own backgrounds and your experiences of life cannot be completely obliterated. And we don't have a single Supreme Court, as I said. We have 15 Supreme Courts sitting on a miscellaneous day because there are 15 benches sitting on it.
Yes.
Unlike some other countries where the bench sits as a whole. So it becomes more challenging because the lawyer feels that depends on where the case goes. There may be that little bit of a difference of perception which will arise.
Okay. What is the role of the judiciary then going ahead? Because we've seen on some very basic matters where the judiciary plays a role that impacts people. I mean, in terms of the cars we drive, and on pollution matters, on seat belts, a lot of innocuous things that potentially have saved thousands of lives over the last few years. On then big matters like Ayodhya. So what is the role of the judiciary going ahead? Is it where it's politically inconvenient and the political class and legislature doesn't want to get involved, leave it to you? Is it interventionist? Is it holding the fort? What's the future?
The footprints of the judiciary in India are quite wide, it is accepted. But it has to be a self-restraint. We can't replace the government mechanism. There is an elected body which comes because that is the mandate of the people. Some people may like it, some may not like it. But then we've chosen the first past the poll system of a democratic process. So it's a check and balance. That check and balance the judiciary must provide in accordance with certain laws. Where the footprints have increased is in some environment issues or 32 issues, Article 32 issues and others, where there has to be restraint, yet sometimes the larger good of the people requires it to intervene. But I'm against intricate intervention. The intervention should be to set the process in motion so that the people who are concerned or the expertise which is there is available to help them in it. We can't be, that's why I said something, understood or not, we are not here to support the government, we are not here to oppose the government, we are not here to support the opposition, we are not here to oppose the opposition. We have to perform a different role. Yes, in a stronger government, the check and balance becomes a little more. Judiciary's role, I believed, was what Justice Sabharwal once told me, that a healthy underlying tension is good for the system, should not be an absolute confrontation. And if there is too much hunky-dory business, the executive and the judiciary, the roles are such, that's not very good.
But in an environment where every political matter, whether who forms government, at what form government, who gets which MLA can be suspended, cannot be suspended, everything is almost immediately brought before the courts, and there is an urgency because some of these matters have to be decided within hours and days. Is the system equipped to just accept the fact that these political matters will often come to court?
Yes, political matters will come to court. The political angle has to be settled outside the court. That's what I mean. But the legal angle has to be settled in court. Now, today we are unfortunately in a scenario where the difference of opinion is large. So, everything is coming to court multiple times, coming to court. And also, everybody has an opinion on everything, Twitter, other handles. So, people, I believe the listening ability has declined, the speaking ability has increased for everybody. So, people will have opinion on something and try to create an opinion when they may not know what that matter is about. That's part of the technology which is in use today.
What is now your overall assessment, sir? Getting away from the technicality of it and the recent experience, you see before you a changing India. There's some things which I'm sure you're marveling at or thrilled about. GDP growth. We are the 5th largest economy. You can veritably see a new sense of energy. There's been a population boom. The average age is 29. So what is your assessment of the state of the union? Are we settled? Are we institutionally strong? Are we heading in the right direction?
So, there has been a lot of change undoubtedly for the positive. We have a greater footprints all over the world. We have a young labor force. But there are challenges within. The challenges within is of creation of employment is the greatest challenge. The quality of education we provide. Literacy is not the answer. The quality of education is important. Equipping the people to make their earnings. These are all challenges which will be faced. And from the judiciary's point of view, the biggest challenge is how to resolve disputes quickly. So, I believe that so many cases in any system cannot see the end of the result. We have to restrict the tiers of scrutiny. We have to work out alternative dispute resolution mechanisms. Government has to decline the amount of litigation it does. That's more than 50% litigation. And mediation is another very important part to move forward. This generation, this technology cannot afford and will not accept litigation pending for years together.
On that note, the concept of decriminalizing, having civil penalties rather than criminal offences, which has recently happened. The concept of community service. Are we sort of going in the right direction? Will that help a little?
Yes, that should help in that aspect. In fact, I had mentioned in some of the judicial order, government somehow did not come back on it, that looking to 75 years of celebration, let us try to reduce the pendency of the lesser cases in the courts on the criminal side. So, cases which have say 7 or 10 years sentence, single incident cases, social economic factors, the man has served already as an under trial. So, instead of taking, if he served 1/3 period as under trial, do you want to take it to the full thing and through the full appeal, or take a bond, a good behavior or something and proceed with it? We have to get these cases out of the system.
So other mechanisms are possible. In a larger context, I know this the subtext of it is still complicated, but on matters like sedition and other laws and reducing the numbers of laws, are we sort of heading, at least are we addressing them, looking to address them?
I still believe if we have too many laws on different issues, the process takes a lot of time and everything gets prosecuted. You have in India a system which 99% cases are expected to be decided by the court. You have an American system which I saw, and I had an opportunity in California where less than 3% cases get to court. So, we have to devise methods by which everything doesn't come to the criminal court. We have had example of say 138 Negotiable Instrument Act. Lakhs of cases keep pending. It was thought to be an expedition remedy. We didn't create an infrastructure. Similarly, the prohibition in Bihar, some stage 16 out of 23 judges is only doing bails out of it. So, there has to be a assessment of the legal impact, institutional impact of bringing in a law in force.
Okay, Justice Kaul, pleasure to have had this conversation. Thank you for your candor and for the wisdom that you applied. Hopefully, we take these larger conversations in the measured way that they required. Because as I mentioned in the beginning, sometimes you need to step back, look at the larger picture, but put the energy which Justice Kaul has, of course, put in his long and glorious career. Thank you for the service that you've done, and thanks for joining us on NewsX.
Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.